Hello, everyone. Welcome to NIJC's second virtual Pride Pro Bono Asylum training. This is part two of two parts of the training. The first part was on Tuesday, and hopefully you were able to join us for that. If you weren't, the recording and the slides will be on our website, so you can check that out after this when you have a moment. We really appreciate everyone coming today to learn about NIJC's work and how you can help by representing an asylum seeker. This training will be geared towards LGBT asylum cases, but we'll be covering the basics of how anyone would put a case together for an asylum seeker. And with me today are some of my amazing colleagues. They were also here on Tuesday, and they make up a large portion of our LGBT project at NIJC. They're also the people who oftentimes will be advising pro bonos. And so we're really excited that you all have joined us. Just before we go into the substance of today's training, we wanted to just give you a little bit of background. I know that many of you were here for the training on Tuesday, so you've already heard a lot of this. But just as a background, NIJC is a legal service provider based in Chicago, though we have offices in Indiana, DC, and in San Diego. We serve around 10,000 non-citizens each year. And we do this work primarily through our network of pro bono attorneys like you all who are participating today. And what makes us unique is that we combine, immigration legal services with like a high volume of that, with a high volume of impact litigation, policy, and advocacy work. And we believe this is critical to our mission and the work that we do because we are able to leverage and be informed by the experiences of the clients that we represent and work with to inform our policy, education, and litigation goals. So, okay, so one thing to note here is that, your representation is extremely crucial to the success of an asylum seeker. Non-citizens in removal proceedings do not have the right to appointed counsel, but when they do, they are 5 times more likely to obtain relief. And so, as you will see today, asylum law, or as you saw on Tuesday, and you will see further with procedural things today, it's incredibly complex. And so, we really do believe that with counsel, asylum seekers can be successful. And if apart from asylum, if you're interested in other types of pro bono opportunities with NIJC, we have citizenship clinics. We help with pro bonos help with asylee and refugees petitioning for family members and also adjusting status. We also work with children seeking special immigrant juvenile status, and then survivors of domestic violence and other violent crimes who are eligible for VAWA and U visas. And all of these are opportunities that pro bonos can get involved in helping with. And so if you're interested, check out our website, but also feel free to reach out to me and I can connect you to the right person. And so I'm just going to briefly go over how we, work with clients, how we find clients, how clients find us, and what resources we have for pro bonos. So when a client comes to us, we receive their referral through a number of different ways, which, through community organizations, through our hotlines, through our help desk at the immigration court. And we conduct, once that, that person reaches out to us or we learn about an individual who needs our services, we conduct an in-depth legal screening to determine eligibility and whether they meet our income criteria. And then once we accept a case, we sign that retainer with them and we start looking for pro bono placement. So even if, we can't find pro bono placement for somebody, we still are going to be representing that individual. And then once the case is placed with an attorney, our team, or team of attorneys, NIJC remains of counsel, and we're with you kind of every step of the way. So even though you're going to be the one to go to court, the one to work with your client, the one to prepare everything, we'll be there to provide technical assistance, document review, and answer any questions that you may have. So today's presentation will cover preparing and presenting an asylum case, as well as working with LGBT asylum seekers. And before I turn it over to my colleague, Tanya, I'm just going to quickly go through some housekeeping matters. So just so you know, the handouts that you'll see, there's 3 handouts today. Is the agenda for today, a copy of today's PowerPoint, and our asylum manual that you can also find on our website. And feel free to download any of those things today. And just so you know, the asylum manual is on our website. The slides will also be on our website, along with a recording of today's presentation. And you know, the asylum manual will be referring to it quite a bit in the presentation, as we did on Tuesday. And that's because there's just so much, a wealth of information in there. And so I really do encourage everyone to review that if you take a case. And then another part of, you know, another housekeeping matter is the questions. If you have questions, feel free to ask and put them in the question box. Try not to use that chat box feature, just the questions would be good. And I will try my best to get to all the questions through the presentation. If we have time at the end, we might highlight some of the questions that were sent in. But if not, and if people still have questions afterwards, you can just feel free to reach out to us, and we'll be happy to help. And then last, we do have CLEs today, and we'll be emailing out those certificates for the CLE at the end of this presentation. Again, if there's any issues with the CLEs, just feel free to reach out to me, and my contact information will be on the last slide. And with that, I will turn it over to my colleague, Tanya.
Hi, everyone. For those of you who may not have joined us last time, my name is Tanya, and I am a senior attorney. As Nisha mentioned, we're going to be talking a little bit about how to prepare your case. This section is, in this presentation as a whole, is where we apply all the substantive tips that we talked about during the last training. And it provides you all of the technical guidance as to how to actually represent someone who's seeking asylum. So if we go to the next slide, one of the first things that you'll want to do when you take a case is generally we tell you whether it's an affirmative case or a defensive asylum case, but the way that you know whether it's an affirmative or defensive case is, as we mentioned, folks who are applying defensively have been put in removal proceedings. And the mechanism through which the government puts someone in removal proceedings is through the notice to appear, which you will see in the slide in front of you. Now, the notice to appear is essentially the charging document in immigration proceedings. It will have your client's number, a number, your client's name, and the list of removability charges against them. When you first receive your case, it's important that you go over the notice to appeal with your client, make sure that all of the information is correct, and note that during your client's first master calendar hearing, you will be asked to plead, or your client will be asked to plead to these charges. If you find any errors in the charges, then it's also important for you to challenge those in court or correct those in court. So then we can go to the next slide. So what are the immediate steps you should take when you take a case through NIJC? We were going to give you a file with all of the documents and intake information that we already have. So it's important that you review those documents to get caught up to speed with our intake process. And then if your client is in removal proceedings, the next step would be to register with the OIR if you haven't done so. One thing to note is that registration requires both an online registration portion, and then also you have to go in person to an immigration court. So you should definitely get this done ahead of the first hearing. And then once you have your EOIR number, or if you already have an EOIR number, then file your E28 with the court. The E28 form is the notice of appearance, and without that, we would not, or you will not get notices of upcoming court hearings or any filings from the government. So even though your client may not yet be set for a master hearing, it's important to get that on file right away in case something changes or some hearing, a hearing gets scheduled. A quick note about affirmative proceedings, we don't generally file appearance ahead of the filing of the asylum application. So we'll file those concurrently, whereas in removal proceedings, you want to file the appearance before you file the application or anything else. And then the second thing is once you file the asylum application with the court, make sure you calendar all deadlines, right? Actually, even before filing the asylum application, once you file the asylum application, make sure that you note when your client will become eligible for employment authorization, but also even before, make sure you calendar all your upcoming hearings, and also make sure you note when your client's 1-year filing deadline is, right? The 1-year mark from when they last entered the United States. And lastly, check the EOIR information line about every week or every other week to check on any changes in your client's case. One thing to note is that EOIR still uses snail mail. So if a court gets set, you may not have notice of that for sometimes up to a week. So it's important to also affirmatively check their systems. Then we can go to the next slide. So what to file? As we talked about before, you're gonna need an appearance form, whether it's before the asylum office or the immigration court. And then of course the asylum application, and there's different procedures for the asylum office and the immigration court, which you can find more details about in our manual, and also through your NIJC point of contact. In this training, we're going to focus on the substantive filings, right? So the legal memo, which is essentially the brief in the asylum office, your client's affidavit, a declaration, and all the corroborating evidence that you will be filing along with the application and the brief and everything else. So we can go to the next slide. Great. So as you start working on your client's case, it's important to keep the big picture in mind, meaning there has to be consistency all across all of the evidence you present, whether it's a corroborating evidence, your legal argument, and your affidavit. Not only does everything have to be consistent, but you have to also make sure to highlight the appropriate information, right? So if your legal argument and the cases that you're relying on, if there's a particular points in reasoning that you want to highlight in your case, make sure that your client's affidavit also talks about those points, and make sure that the evidence has those points, right? So really just think of the big picture throughout the process. And we can go to the next slide. Great. So then after the immediate steps, after you have all your calendared notes, you have entered your appearance, so on and so forth, then what is the next step? You should contact your client, of course, explain your role, the roles of confidentiality, and also more than anything, the first steps before the hearing is your best chance to build rapport with your client, right? Talk about where they are and what their immediate concerns are, and build that trust relationship with them. Also make a plan as to next steps and what they can expect in terms of communication, and what your expectations are as far as communication in meetings, and so on and so forth. You will need to also get your client's signature on various forms, so make sure to do that. And then the second step would be making sure that you have your client's complete immigration history. Now, if your client was recently arrived, you may have the notice to appear may be the only document in their immigration history. But if your client has entered multiple times, or particularly if your client has been in removal proceedings in the past, you want to make sure that you have the entire file. Sometimes, for instance, in the case where your client has been in removal proceedings in the past, you want to make sure that you FOIA for the complete court file. Otherwise, also just make sure that your client is able to the extent that they can, give you the documents that they have. One thing to note is that there is no discovery in immigration proceedings, and there is also no formal docket that you can pull from. And then once you have all your ducks in a row and you have all of the past history and our notes in your radar, then start preparing the skeletal asylum application. That should be fairly straightforward once you have all of that information. And then from there, once you have a sense of what the asylum application will contain, then start drafting the declaration, which is the next section we're going to talk about. And we can go to the next slide. Thank you. So one thing to note about drafting your client's declaration is that this is the part that's going to take the bulk of your time in preparing their case. As we mentioned in our last training, credibility is the most important part of an asylum case. As we mentioned, it is a necessary component of a finding of a well-founded fear of persecution. Without it, essentially, your client is precluded from obtaining asylum. And another thing to note is that credibility determinations don't have to be based on the merits of the case, right? It doesn't have to be an inconsistency about something that goes to the heart of the claim. It can be based on demeanor. It can be based on an immigration judge just finding that your client's case is not, or story is not plausible. And it can also be an adverse credibility finding. It can be based on minor inconsistencies as to dates, ages, and so on and so forth. So it's really important that you have a clear understanding of what your client's story is, and the declaration is your best chance to get all of that information in one place. And now I'm going to turn it over to my colleague Lee, who's going to talk to us more about declaration preparation.
Thank you, Tanya. My name is Lee. I am a supervising attorney on the project. And given how important Tanya was just saying about how the affidavit is a primary source of your evidence, how you're going to spend a lot of your time here, we wanted to take a couple of minutes and talk a little bit about best practices for the interviews and the client preparation that you will be doing, especially with trauma survivors. So, almost inherently, all of your clients who are seeking asylum are trauma survivors. So, when you're here learning about taking on an asylum case, it's not just about the new law. That was mostly the focus of our part one, but we're also learning how to interview and to interact and to learn from trauma survivors as well. So up on the slide, we have a couple of tips for how the science says, how evidence says it's best to work with trauma survivors. So maintain frequent contact and for a limited duration. It's not something that you can have a mega meeting and spend 4 hours all in once trying to get the facts that you need to form an affidavit. That will probably be really overstimulating and re-traumatizing to your client. And then provide empowerment through choices. So it's not, you want to have a reciprocal relationship as much as you can with your client. Let them choose what topic they might want to do. And then contextualize, explain the objective of your questions. So it's, don't be morbidly curious, but also explain that for an asylum case, there's certain elements under the law that you need to meet. And the way to do that is to get the client's story. So then, asking short questions, asking, straightforward questions using plain language are other ways, especially if someone is experiencing more of an acute crisis or it's harder for someone to recall their story. Again, like with the point right next to it, don't expect chronological, complete consistency. That's just not how trauma works. And it may be a little frustrating at times, like, oh, well, why can't they just remember? Because oftentimes there's changes in the brain that make someone not be able to remember. So just have the knowledge of that. Try to be best equipped with the tools that you can. And you can also work with NIJC to get other supportive services for that client. I always try to help clients engage in psychotherapy and any other type of mental health treatment because the process of seeking asylum is re-traumatizing. So having that kind of as your baseline and the understanding of that for your clients is really important and helps shows that obviously you care about your client as a client, but also you care about them as a person. The last thing here is to bookend the interview. And what that means is I kind of think it almost, like a bell curve. You start and the very first question you ask isn't, tell me all the details of this traumatic incident. You start out by maybe, if you're, well, in a day when we might be back in person, you might offer them some water, check in, oh, how was it like getting to the office today? And then from there, you can go into more of the substantive conversation and make sure to leave time at the end of your appointment. Don't end with oh, okay, now you've told me all these traumatic details, goodbye, see you next week. Because that kind of shock isn't helpful for a trauma survivor. So build in time at the end to wind down, to have a short conversation with something that's not the subject of their trauma. These are just a couple of tips. There's also other really great resources, especially with in social work that I draw from too, as best practices to try to avoid re-traumatizing someone. And if you were here on Tuesday, you know that we are going to introduce some polls. So if we could start our first poll. Okay, so no, these aren't rules or prescriptions, but just to get us thinking, to get the wheels moving, what would be an important step in working on an affidavit with a trauma survivor? Give them choices on what topics will be covered in the meeting. Allow time to de-escalate and conclude a meeting. Ask single part questions, or all of the above. Okay. I can see most of us have voted already, which is great. Thank you for paying attention. And yeah, I wasn't trying to hide the ball on this. All of the above. All of these are really great ways that you can work with trauma survivors and to have the most productive and the less re-traumatizing experience that you can. Okay, we can move on to the next slide. Okay, so we're working with our client. We're being as trauma informed as we can be. We're getting the information that we need to help draft that affidavit. What language do we use? How do we actually write it? So our goal in an affidavit is to tell the client's story in their words, but also in an organized way. So here we see some not very helpful ways that you might be tempted to draft. So the first one, not in the client's voice. I was persecuted because I belong to the group of Salvadoran females in relationships they are unable to leave. While that might be a particular social group, like we learned about in the last training, that's not usually what our clients will say. Clients might not use those terms of art. So that is a great thing that you would use in your briefing and your legal argument, but not so much in the client's affidavit. So the second one, too much legalese. Words like, belatedly came to ostensibly investigate, but their investigation was cursory and superficial. Things like that. If that truly is the way that your client speaks, then work with that, of course. Reflect how your client would tell their story, but especially when you're citing to other evidence, that is what a legal argument does. That's what you will do in your briefing and in your legal argument, not so much the place in the affidavit. And then the too much detail. This can be a thin line for sure, because you want to use enough detail that would form the basis for the relief, because the affidavit is the single greatest piece of evidence that you will have. However, you want to also set them up for success and not set them up for, as Tanya mentioned, this adverse credibility finding. So make sure that the details that you do include are consistent. Your client consistently remembers them in the same way. So definitely back and forth on including enough detail, but not too much that you're setting up your client for failure. Okay, next slide. Okay, so we have our affidavit. We've done very well at organizing and putting in our client's voice. What next? Next, we talk about corroboration. So we want to have corroboration as much as we can. And it is really important to not leave off, because, especially if we're working with friends and family and country of origin, so, the mail takes a little bit longer that way. So definitely don't leave this to the end. So as you can see, corroboration is required unless we don't have the evidence and we can't reasonably obtain the evidence. So let's imagine that there was, your client went to the hospital, and a hospital report would exist, but your client can't get it for A, B, and C reasons. You should kind of step in front of that and explain that. We do have in the regs, as you can see, the credible testimony can be sufficient to sustain the burden of proof to win asylum. But of course, if we can add more evidence that helps out the case, of course we will try to. So when we were talking in our initial presentation about those 5 different elements, the 5 different parts of the asylum definition, think through every single part and how can you corroborate? How can you back up your client's story for each part of the asylum definition? Or again, unless you can't get that evidence, show why you might be unable to. Okay, next slide. Great, okay. So here we have a chart that has many different kinds of corroboration that might be available to your case. So we can just look at a couple of these. So country conditions, again, that really goes to the element of whether the government is unable or unwilling to protect your client. So the State Department human rights reports that come out every year, different NGO reports, and then even domestic and foreign news sources. So any type of thing that talk about the conditions that a person like your client would face. Especially if you're working with our LGBT clients, these are sources that we maintain. We have sample PDFs and indexes that list out a bunch of different helpful articles. So be in touch with your NIJC point of contact as you're working up those cases. Next column over, we just have things about your client, manner of entry documents, any sort of physical evidence, witness affidavits, or letters of support from friends and family. At Google Earth hand-drawn maps, I actually had a case where we did try to use maps quite a bit because the client just had a lot of trauma and locations were really hard for her to remember. And then corroborating past persecution. We have things like here, like different medical evaluations, medical reports, photos of people's injuries. And then for future persecution, this is where more letters of support might come into play, expert witnesses, and again, like in that first column, those country conditions resources. And these are just some examples, right? Just be creative about the types of corroboration, other types of evidence that might be available and might exist for your client. Okay, and I think we are ready for our next poll. So again, I don't want to be too tricky with you about this, but out of those three options, what do you think would be the most useful type of corroboration for your client's case? So general or generic information about the country of origin, a short letter of support from an acquaintance, or a forensic evaluation. Take a sip of water while we ponder on that and get some votes in. Okay, about two-thirds of us have voted, so we're doing good so far. Okay. So my pick would be the forensic evaluation as the most useful out of the three. And here's why. That will contain the most individualized and specific information about your client. So a generic or general information, it's useful to have country conditions evidence, but you want to tailor that as much as you can. So for example, if your client is a gay man from El Salvador, how children in El Salvador are treated might not be as useful, of course, unless there was some past persecution to them as a child. That might be a little bit more useful, but you want to get as specific as you can to corroborate your client's case. And as just a very quick footnote, there is actually some case law that generalized violence isn't good enough, is not good enough to establish an asylum claim. So if you're flooding the country conditions evidence with generalized violence, that could actually cut against your client's claim. So the second option, a short letter of support from an acquaintance. I tried to tweak that just so that it's less and less useful, because if it's just, hey, I know client and he's a good guy, that doesn't really speak to the past persecution or the membership in the particular social group or the future fear. While it's good for, maybe it might be good for discretion to show that people are in that guy's corner, it's not as helpful in proving the different elements of the asylum claim. So again, my pick here for the most useful will be the forensic evaluation, which would hopefully really help corroborate the past harm. Okay, next slide. Great, and we've made a couple of references to this so far, but as we are working up the case, getting all the evidence that we need, then the next type of thing, the next document you'll work on is that legal memo for affirmative cases or brief for defensive cases. So not to be too quick, but keep your brief brief. There are page limits. There's a 25-page limit in immigration court, and you really just want to draw out the proof of your case. It's not a law review article. You're really applying your client's facts to relevant case law. Like we talked about when we were talking about the elements last time, follow through each of those 5 elements that we spoke about. Don't conflate them. It is tempting to do so, especially between whether harm rises level of persecution and nexus especially, but keep it separated out because each element needs to be shown independently. And then, when you're citing to case law, focus on the helpful circuit law. Of course, some BIA presidential decisions you just use, but focus on that circuit law when it's helpful. And it changes all the time. As some of us on the call may have seen, we just had a lot of vacation, as it were, yesterday of AB and LEA. So case law is changing all the time. Thankfully, this was a useful change. We'll wait and see what happens with rulemaking, but keep up to date on that. And very similarly related, send it over to us for review. So your POC, point of contact in this context, will let you know more specifically around the timing, but give us at least 5 business days when possible. That way that we can give it the attention that it deserves. And it's similar to following through the elements. Preserve all your arguments, preserve all your claims to relief. Don't leave an important thing out. So there's another tightrope line between keeping it brief and succinct and also preserving your arguments. So you can work with us in what to whittle down, what to expand on. You know, legal writing could be fun, and we are here to help with that. Okay, next slide. Okay, so filing format. So again, this does depend a little bit whether you are affirmative at the asylum office or defensive in immigration court. But the immigration court does have a practice manual that lays out the filing format. For both affirmative and defensive, you will utilize an index. It kind of goes, you know, brief or cover letter, and then the index, and then all of the supporting evidence, which has your client's affidavit on top. So in the index, you'll want to, especially for those country conditions, reports, news articles, things like that, you'll want to highlight, you know, pull up some of the important quotes from those articles. Then just a little bit more practically, you will have exhibit labels or stickers on each of the evidentiary exhibits, as well as tabs on the side. And don't forget to paginate, paginate everything. So when you're and now that you have your, you know, large stack of papers, you will file it, you know, either to the asylum office or to the immigration court. With COVID, and as we're through and coming out of COVID restrictions, how the filing process looks can be a little bit different, but traditionally I would go to the court and file that at the window. So the important kind of sub point here is to make sure you have the certificate of service, and then actually serve it on the OCC, on the government. Like Tanya mentioned, anything that you are filing in court, you also serve a copy on OCC. And then for the asylum office, like with the 589, you have 3 copies that you eventually give them, but my best advice, at least for the short term, is to contact either the asylum office or the court that you will be filing at to get their most up-to-date guidance on how they want you to file. Okay, and now I'm going to turn it over to Beck.
Thanks, Lee. Hi, everyone. My name is Beck Earl. I use they or she pronouns. I am a paralegal on the LGBT team here at NIJC. So in the first part of this training this week, we talked about the different identities that members of the LGBT community have. And in this portion, we'll talk more about best practices, specifically when working with LGBTQ clients. If we could go to the next slide, please. So this slide is just a refresher from part 1 of the training. Up here we have the Gender Unicorn, which is a great resource that was developed by the Trans Student Educational Resources. So you can see, just as a reminder, that gender identity, gender expression, sex, physical attraction, and emotional attraction exist on a spectrum. This is useful to have in mind when working with LGBT clients because it provides a helpful reminder of the diversity of LGBT folks. Also, just as a refresher from part 1, it's important to be flexible and open to changes that people may have regarding their sexual orientation and gender identity. For some clients, their understanding of their LGBT identity may change over time, and it's important to respect the name a client chooses to use, the pronouns they identify with, and the terms that the client prefers. It's okay if mistakes happen, and you can learn from that mistake, apologize, and move forward. It's good to give clients space to be open with you if their feelings change about their gender or their sexual orientation over time. Being open and flexible will help in building a trusting relationship with the client. And now we're going to have a poll before moving on. So your client tells you that he is queer. Then you ask him a question about his sexual orientation. Which word should you use? All right, we have about half of the votes in. Okay, so the correct response to this poll was to use the word queer, because you should always use the language that your client uses, and we'll discuss this more in the next slide. So these next few slides will cover some practice pointers for working with LGBT clients. The first tip, which we saw in the poll that we just completed, is to take cues from your client by mirroring the language that they use, including but not limited to for their name, pronouns, and terminology that they identify with. So up here, our first example is the poll, similar to the poll that we just did. So for example, in that poll, if your client says that they identify as queer, that is the word that you should use to refer to your client. So we have another example up here. If a client says, I am gay, you should not respond with, how long have you been a homosexual? In that scenario, the proper word to use would be gay, because you should mirror the language that the client has already used, and use the word gay when speaking with the client about their experiences. So for our second example, if your client is transgender, you should ask what name they prefer to use as a first name, and then make sure that you use it. If your client is transgender, you should refrain from using their legal name if it differs from the client's chosen name when speaking with the client directly. You will have to list the client's legal name on applications, and you should be open with the client about this and about why you have to list it. But when referring to your client in conversation, you should always use their chosen name. So our third example up here is if you're unsure of your client's preferred pronouns, to ask about it. A few appropriate questions would be, what name would you like me to use? What is your gender identity? And what pronoun should I use? It's also good to know that sometimes your client's preferred pronouns may change as their understanding of their identity changes. Next slide, please. So as we saw in part 1 of the training, there are a lot of diverse terms that LGBT folks use to express their identities. The terminology that's used to refer to individuals who identify as LGBTQ changes all the time, so spend some time making sure that you're referring to your client in a manner that they will respond to favorably. We have some useful resources listed up here, and we'll also let you know at the end of this presentation how you can access this webinar later as well. Next slide, please. The last tip that I'll be sharing is to account for cultural differences. It's important to remember that our own perceptions of what it means to be LGBT may not be the same in every country. Your client may not be familiar with some of the language that we've gone over throughout these presentations, and likewise, they may use language that you're not familiar with. So we have a couple of examples up here that you may run into scenarios like this. So first, when speaking to your client, just like we went over earlier, make sure that you use the terms that your client uses. And then when writing your brief, use the terms that are used in the United States. So for example, the Spanish term travesti is commonly used to refer to transgender individuals, but it translates directly, literally, to transvestite, which is considered offensive in the United States. And as another example, some Spanish speakers will prefer to refer to their sexual orientation as sexual preference. So that's another example of a cultural difference that you should be accounting for in conversation with your client. So in the first example, you should use the word transgender in your brief, not transvestite. Another example is that some clients may identify as homosexual. We wouldn't write that in the brief and would instead use an alternative word, such as gay or lesbian. Lastly, the movement towards gender neutrality is being discussed everywhere, including many of the countries that our clients come from. For example, in Spanish, the use of ella, ellas, or the @ or X instead of an O or an A is being discussed. It might not be something that our clients are aware of, but it's good to be familiar with the fact that gender-neutral pronouns are out there and are being used by many people across many languages. Next slide, please. So now we'll talk about applying these tips. First, familiarize yourself with and use appropriate terminology. It's important to familiarize yourself with terminology in English, as well as any other language that you'll be using with clients to help normalize the process of discussing the client's identity and to help the client feel comfortable speaking with you. Recognize that you're going to have to talk about sex and romantic feelings with your clients. When you ask a client about their sexual and/or romantic history, keep in mind that the dating culture of their country of origin is likely very different, and same-sex dating is probably completely taboo. Just because someone hasn't had open relationships in the past doesn't mean that they don't identify as LGBT. The same goes for gender identity. Just because a person has not had the opportunity to transition in any way, including pursuing gender-affirming medical care, that doesn't mean that they don't want to. Think before asking about body parts and sex acts. Many people are curious when it comes to transgender bodies, but most of the time, it's really not relevant for you to ask questions about people's body parts. You should always very carefully ask yourself, why am I asking this question? Do I need to ask it? And is it relevant to the client's legal case? If it is necessary in order to better advocate for your client, then be sure to tell them that. In general, when asking personal questions of clients, as Lee touched on earlier, it's helpful to explain why you need that information for the client's case. Many transgender people are used to people asking them intrusive questions, and you need to make sure that you're not asking only because you're curious. Lastly, be sensitive, but be direct and respectful. Always maintain clarity and openness with the client. Next slide, please. Now we'll talk about representing detained LGBT clients and some pointers specifically for that situation. Firstly, detained clients are more likely to have crimes or previous removal orders that may limit their eligibility. That's something that will need to be taken into account in each unique situation for the client. Secondly, communicating with detained individuals can be difficult. Each detention center has its own rules regarding scheduling legal calls. For example, some have strict lockdown times or meal times during which you can't set up calls. Some may be in different time zones. Some only allow you to schedule calls in certain ways, either via email, fax, or by calling an officer. Unfortunately, sometimes it is not possible for clients to make calls in private areas, and they may have to make calls from areas where other people can hear them, and they may not be comfortable sharing their experiences of harm or regarding their LGBT identity during those calls because it's extremely personal. Many detained LGBT folks are also afraid of being outed and being assaulted or abused while they're detained. It may take more time for a client who is in detention to open up to you. Similarly, if a client does have to make a call in a shared space, they may not be comfortable telling you about any adverse detention conditions they're experiencing, as they may not want guards to overhear them. Next, detained LGBT immigrants are especially vulnerable to sexual abuse, which may make it harder to get a full story from clients. Especially for detained clients, their explanations of traumatic events may not always be in chronological order. That doesn't mean that the client is not credible. It just means that they're working through processing the traumatic event. It's good to ask what order things happened in if that's helpful to the case, particularly for the affidavit, but it's also important to avoid questioning the client's perceptions of their experiences. Detained clients do not always have access to their friends and family to help with evidence gathering. Detained clients get all of their belongings, including their phone, taken away when they're detained by ICE, and that can make it difficult to reach friends or family. It's important to know that using the correct gender pronouns and addressing the client by their preferred name is especially important in the detained context. The client may be misgendered or addressed by a name that they are not comfortable with while inside of the detention center, which is very triggering and stress-inducing for the client. Addressing your client in the way that they prefer just shows that you respect them and helps the client to feel safe and comfortable with you. As practitioners, we should be doing anything that we can to lessen the trauma of being detained. Thank you. And with that, I will pass it back over to Lee.
Thank you very much, Beck. Really great tips and practice points for us all. Okay, before we dig into the very last part, before we talked about preparing our case, this last part we're going to talk about presenting our case. Before we do so, though, we are going to have our last poll of our webinar today. If we could launch that, please. Okay, so bringing it all together, if your client is in defensive proceedings, where will the case be adjudicated? Immigration court or EOIR, USCIS, or the asylum office? So which of the three agencies or part of the government will have your case if it is a defensive case? Okay. So we have most of our folks in. Excellent job, everyone. We're learning. So yes, you are right. Immigration court or EOIR, that's where your defensive cases will be venued at. All right, we can move along to the next slide, please. So this is another kind of diagram of the asylum system and the different ways these parts interact with each other. So on the left-hand side, we have the affirmative process, which would be at the asylum office. So your client is in the US, but they have not been issued an NTA, which, as Tanya told us, means they're not in removal proceedings. So you file the affirmative application, and right now those are mostly filed at the Nebraska Service Center, but check in with us before filing just to be sure. So then you're filing your I-589 affirmatively. Then eventually you and your client will be scheduled for an asylum office interview. You'll file all of your legal memo, your supporting documents with the asylum office. You'll attend that interview. And as our little blue squiggly banner says, it's non-adversarial. So it's not court, it's an interview. The result of that interview can be a grant or a referral. So then, obviously we love a grant, but not all asylum cases get granted. And if your client doesn't have other legal status, then they'll be referred. And you see the little arrow go over. The referral process starts with being issued a notice to appear. So that puts us in removal proceedings. However, if your client starts out defensive, so if it's an unaccompanied immigrant child that was apprehended, or if your client is an adult that was either apprehended at the port of entry or internally, then they are still issued that notice to appear and then go to the master calendar hearings and the merit hearing. So we'll talk a little bit more about hearings later, but just master calendar hearings are similar somewhat to status hearings. That's usually the time when a client will plead to their NTA, will schedule the merits hearing. Sometimes clients are able to seek some continuances while they're looking for a lawyer. And then the merits hearing is where you lay out your case. We'll talk a little bit about that again later, but that's where you present your evidence, where your client gives their testimony, where the judge will take in all the evidence to decide. Next slide, please. So on the affirmative side, when we're at the asylum office, the timing is still pretty wonky, I'm not gonna lie. So if your client filed before 2018, the timing is pretty unknown at this point. The reason why is that in 2018, if I remember right, I believe it was February, around that winter time, the asylum office changed its scheduling policy to last in, first out, meaning that they were scheduling recent applications and then they were leaving the backlog pretty much still in the backlog. We're still really feeling the ramifications of that. because in my experience, we're seeing those newly filed applications being scheduled very quickly. So again, that's why it's really important to start right away communicating with your client and right away getting that corroboration started. So no matter when you did file, you'll only have 2 weeks notice between the notice of the interview and the interview itself. So as you can see in the chart, you get your interview notice, and then in a week from then, so in between the notice and the actual interview, ideally that week before the interview itself, that's when you're going to file your legal memo, the index, all the supporting documents with the asylum office. And then again, you and your client will go to the interview itself on the date that the notice says, and then you'll receive your decision. Right now, because of COVID, at least in Chicago, they're mailing out all the decisions, but there's a huge variation between when you will receive your decision. Could be as little as 10 days, 2 weeks, or it could be many months. Again, as our little yellow note says, the timing of just having those 2 weeks is difficult itself, but also there's enough significant changes that have happened and that probably will happen in the future that will affect that timing. Okay, next slide, please. Okay, now on the other side of our coin, the case timing for defensive cases. The chart is a little small, so hopefully you can read some of it, but what this chart shows are the amount of pending deportation cases by state in fiscal year 2020. So, we have California, Texas, New York, Florida, New Jersey, Virginia, and then Illinois. And then below we have Massachusetts, Georgia, and North Carolina. Really, what you can see from here is there are a heck of a lot of pending cases, and there's a lot of variation. So, in either or any situation, there are definitely backlogs in the immigration court system. So you can really anticipate that your client's case could be pending for many, many months to years. But like with the note for the scheduling asylum office, interviews and those types of things, there are enough changes that are proposed or have occurred with EOIR. So one example is this push really to eliminate or limit master calendar hearings. You might have seen some of that buzz going around. We've seen a little bit of both ways, to be honest. So check in with us definitely before your master calendar hearing. As was said earlier, check the EOIR hotline frequently to monitor when your court dates are. There's also an online version that they debuted, what feels very recently, but instead of calling the 800 number, there's a website you can also go into, enter the A number, and it will show the next hearing date as well. So keep your eye on that. Help manage your client's expectations that it is an unfortunate reality that these backlogs exist, and especially with the cases that have been canceled during COVID, some of those have not yet been rescheduled, so that could also be contributing to future backlog. Okay, next slide, please. So either way, any asylum case that you have, the biggest goal possible, stay in touch with your client. If especially they're in this pre-2018 at the affirmative level or just in the defensive backlog, things might change in their life. Like we talked at the end of Tuesday's presentation, there might be other things that happen in their life that make them eligible for different relief. And also you and your client really is under an obligation to inform either USCIS or EOIR, sometimes both, of their address within 10 days of moving. So if you're not in contact with your client, you might not know if they've moved. One really devastating consequence of that, potentially, which of course will not happen to you because you're here at our training, but if your client, let's say, if they move and then you've lost contact and a hearing date comes up and they don't know, then they could be ordered removed in absentia. So they could get a removal order because they didn't know when a rescheduled court date might be. So that's one huge important reason to stay in touch with your client. But obviously developing rapport and having that trusting relationship with a client is very important. Like I mentioned a bit earlier, especially when we were talking about trauma-informed lawyering, try to connect your client with any resources they might need, especially therapists, especially medical doctors. There are some other types of social services, especially for immigrants and asylum seekers. Especially if you're in the Chicago area, we have a pretty good pulse in those resources. We can help you with that. But you also definitely work with your client directly to help them with what they need to help establish some stability, because in my experience, when your clients have a little bit more stability, their ability to really work through their trauma and their ability to share that with you and be active participants in their cases improve with the amount of stability that they have. Okay, the next point, if your client is in defensive in removal proceedings, it's your job to request biometrics. One second. Okay, so clients need to be fingerprinted and the government runs basically background checks. For the defensive context, you need to, and there's instructions for this, and we'll provide you with those instructions, but you need to mail basically in a request for your client to be fingerprinted in order for that appointment to happen. And it's just one of those things that there is a lack of communication maybe, but there's a difficulty in getting those appointments scheduled. So we recommend 6 months before the hearing at least get started on that process. And then work authorization. We're going to talk more in the next slide, but keep up with the work authorization applications and track the renewals. So if we can go to the next slide to talk a little bit more about work authorization. Okay, so huge caveat with this slide. There's been a decent amount of changes and back and forths about work authorizations, so keep in touch with us. But like it says at the bottom, work authorization is so important. It really is a life changer for people to be able to live independently, to get their needs met independently. So the asylum clock is a little tricksy, I'll say. So it starts when the asylum application is filed. So for affirmative cases at the asylum office, when USCIS receives it, or defensive when it's received by the immigration court. So then you can apply 150 days after that date, and then they can issue it 180 days after that start date on the clock. However, there are a number of things that can stop this imaginary clock. If the biggest kind of the overview of it is if the applicant causes a delay. So if your client doesn't show up to their asylum interview and then gets referred, or if you request that to reschedule that asylum interview, that's a delay that you and the client caused. So that stops the clock. So then if your client hasn't yet reached 150 days after submitting their I-589 or their asylum application, that could preclude them from being eligible for work authorization until the clock restarts, which could be quite a long time. Another potential delay is a change of venue, that you can ask the court to restart it, but that is definitely not as straightforward. So keep that in mind, really monitor that date. For my cases, I calendar that. I write it in, I put a reminder, this is when my client's going to hit 150 days if I file it now. So yes, that's one thing to definitely keep in mind. And then for filing the work authorization, it's a different form as the I-765, we can help you out with cover letters and guidance on how to fill that one out. That you also should keep in mind the filing fees. Those fees have changed and then not changed and then changed again. So reach out to us when there still are questions about what's the appropriate filing fee. USCIS also, if you go to the page that houses the form, then you also can see what is the filing fee. There's a little drop down and they have up-to-date information there. As a general tip for asylum cases, really for any immigration case that you'll be working on, check the validity of the forms. The forms change. Back when I was a baby lawyer, the I-765 was 2 pages. Now it's 7 pages. The forms just change over time. And if you submit an outdated form, it will be rejected. So I always, when I'm working on a new application, I always just go to the website, download the most recent version of the form there. So that's something to keep in mind for renewals. So if your client, to the bottom point, if they already have an EAD, then renew that EAD 180 days before it expires so that there is gaps. So that, so there are not gaps. We do not want gaps. Many places will kind of tie someone's driver's license, for example, or other identity documents to the employment authorization document. So really try to keep as very close contact with your client, but also close records for yourself about when that EAD is going to be expiring and when you can renew. Right now, asylum applicants, the category under that makes them eligible is under C8, and usually those last for 2 years, but that is something that you should just make the note of, be on top of, because again, that work permit allows them to obtain legal employment, which can be a huge change and can really help keep someone safer instead of having to rely on underground, under table sources of employment. Okay, next slide, please. All right, so preparing your client for the asylum office interview or the merits hearing. So in either, kind of how we do it, or a way that's good to do it, is have 3 kind of prep sessions. So one where you do a full prep, the next you're a little tougher, you're a little bit playing mean lawyer, and then the last for a confidence builder, something to really get them on stable ground to prepare. So when I'm saying the preps or the preparations, I'm mostly talking about preparing the direct examination of your client and of any witnesses. I also will prepare, and you also should prepare your clients who are in removal proceedings for cross-examination. So a little bit more on that in 1 second. So explain the process, practice accordingly. At the asylum office, again, if we remember in that little blue banner, it's non-adversarial. However, that doesn't necessarily mean pleasant experience, because your client's still talking about their trauma and some of the worst things that have happened to them. But how it is, you can see in our incredibly artistically rendered diagram, this more or less what the layout of the asylum interview will be at the asylum office. The AO box is the chair where the asylum officer is sitting. That larger rectangle is their desk. Then the U box is the client. Next to the client is the interpreter. The me box is the lawyer. They usually just put us in the corner, and that's okay, because at the asylum interview, your role is more observational. The officer will be asking the questions to the client, and the client will be responding to the officer. We have a note here that you provide the interpreter. Right now, during COVID, that they are phoning in the interpreters, so unless it's a rare language, but generally in post-COVID times, as we're getting there, you will provide your own interpreter. They don't have to be a certified, professional interpreter, but definitely don't have a friend or family of the client be the interpreter. And then the process for the merits hearing, which is the defensive application, is a trial, really. It's the merits hearing. So the diagram would look a little different. There's the judge, the clerk, an interpreter there as well. But the biggest difference is that there's going to be your table with you and your client, and then the government's table that will have the trial attorney. So that is run a little bit more formally. It's an adversarial experience because it's a trial, it's a hearing. You will be able to have a direct examination of your client, but depending on the judge, there's some Chicago judges that really love peppering in their own questions. But then after your direct exam, the trial attorney will have a cross exam. Almost always you can have a redirect afterwards, but just prepare that that process is definitely different than the affirmative one. So your direct exam has open-ended questions, the who, what, when, where, whys, and hows. I recommend that you basically kind of just write out your questions. What is the information that you want to elicit for your client? What do you want your client to share with the court in order to support their claim? So in that vein, talk with your client beforehand, practice your direct examination with your client beforehand. Make sure that your client is empowered with what the elements of asylum are and how you're using their testimony and their life story for their case. And then of course, part of that prep is to explain possible results and manage expectation. Who's going to say what could happen at the end. One really important, and so sorry, before I get to the next part, we're going to, in a couple of slides, we'll talk about what happens at the end. So don't worry, we'll get there. But one important thing to remind your client while you're preparing them is that, it's their interview, it's their hearing. This is the thing that decides their case. So empower them to say, I don't know, I don't understand, please repeat. I always tell my clients, it's better if you aren't quite sure to have them repeat the question than for you to guess and give them information that they weren't expecting. So share with your client that yes, they can ask to slow down, they can ask for a break, they can ask for questions to be repeated. Okay, next slide, please. Okay, what happens after the individual hearing? So we saw a little bit earlier, if after the asylum office, if they grant, great, they have asylum. If they refer, then they go into removal proceedings, which gets us down to the individual, also known as the merits hearing. So this is also a throwback to last training where we talked about the differences between asylum and then withholding of removal and relief under the Convention Against Torture. So under asylum, if the immigration judge grants, then that's great, yay, we win. But both parties are able to appeal and have the right to appeal. So if the immigration judge grants and the government waives and ICE waives appeal, then we win, your client has asylum. If your client is detained, then they will be released very soon. If they were brought into the hearing, they could be released immediately after the hearing, or if they were videoed in basically for the hearing, then they can be released probably the next day. So practice pointer here, if you are representing a detained client, figure out the release plan. Figure out, are they going to be transported by ICE to somewhere else? Either way, who can pick them up? Where will they be living? There is an organization in Illinois called the Interfaith Committee for Detained Individuals that can help with some of that release planning, but it's best if you work with your client and your client's family if they are participatory and supportive in making those plans. well in advance of the hearing, because we want to plan for every situation, including winning. Let's say that they grant asylum, but the government appeals. So in almost every scenario, then your client will stay detained, if they are detained to begin with, until ICE either files their notice of appeal or doesn't. They have 30 days between the immigration judge's decision and the appeal deadline, basically. If the immigration judge does not grant asylum, then you should reserve appeal. For withholding and CAT, somewhat similar. If the government waives appeal, the difference is procedurally, the immigration judge will order removal, but then withhold or defer, depending on the case, that removal order. And then ICE later, if your client is detained, ICE will later release that client usually with an order of supervision. One thing to note here is that ICE can keep your client detained for a 90-day period while they look for another country of removal, which, in my opinion, is punitive. But again, that is their right to do. On the flip side, if ICE does decide to appeal, again, your client will, if detained, will remain detained during that 30-day appellate period. And then if they do appeal, great. If they don't, then great, better, because then you can seek release for your client if they are detained. Okay, next slide, please. So if you have an affirmative case and the asylum office grants, great, let us know right away. The most important reason why is that the different, as they're called, like refugee resettlement agencies, there's this 30-day deadline in which a client can sign up with them and receive benefits. So it's important to let us know right away so that we can help connect your client to some of those agencies so they can get the food stamps, other types of benefits that they are eligible for as soon as they can. So work authorization, social security card, benefits, those are some next steps. Asylees are legally authorized to work. They don't need the EAD card, but many like to, so they don't have to explain things to their employer. Usually the asylum office issues those automatically, so that's the thing to keep in contact with. A social security card, you can get an unrestricted social security card. Otherwise, it says only valid for work authorization with DHS, meaning that they need to also show an EAD. But as an asylee, they can get an unrestricted social security card that doesn't have that language. And then one last thing to do, asylees can be eligible to petition for derivative family members. So that's a great thing to do, get started. In the situation, if asylum is not granted and if your client is referred, then they get referred for a de novo review, meaning that they get a second bite at the apple, another chance to argue their case in front of the immigration judge. So now they're in that defensive removal posture. So again, like we said earlier, the procedural thing that happens is that the Department of Homeland Security issues a notice to appear. So that puts the client in removal proceedings, and then the client moves forward as in this defensive posture. And again, in that case, definitely notify us right away so we can talk about what next steps that the client, that you are going to take. Next slide, please. Okay, so we're in the defensive side again. Thanks for going back and forth with me on that. So after our merits hearing, if we win, and let's say we're in the all green column before, where we win and DHS waives appeal. Again, we still have that 30-day deadline for benefits. The extra step that we need to do in the defensive posture is that we need to go back to USCIS to get the client's I-94. So you may recognize that or be familiar with the entries and exits, and I-94 in that sense. This I-94 is a main proof of asylee status that the benefits agencies, the refugee resettlement agencies, will sometimes require as almost a prerequisite to applying for some of these benefits. Then, like affirmative, work authorization, social security card, those benefits are very similar. And also referring back to NIJC for those derivative family members. All of this is very similar. The extra thing between affirmative and defensive after we win is to get the I-94 from USCIS. That process can be a little frustrating, but we're definitely, NIJC, your point of contact here, is definitely here to help wayfind through that. So if asylum is denied, reserve your right to appeal. Usually, if it's an oral decision, the immigration judge will just say, oh, counsel, are you reserving your right to appeal? But you check it, so yes, and then check in with us right away. Like I mentioned on the DHS side, there's this 30-day period in which to appeal your decision to the BIA. So keep on top of that and talk with us right away to help us figure out next steps. Okay, and that is it for me. And then back to Anisha, I think we probably should have some time for questions if there are any.
Hi, everyone. I hope that you learned a lot today, and thank you for joining us. As the slide says, there is a like a survey that we'd love for you all to take. We really do appreciate your feedback and we value it. So you can put your phone up to the QR code and it should take you to the website that's also listed at the bottom. And if, for whatever reason you have any questions that you didn't ask today, you can feel free to email me or check out our website. And yeah, we look forward to hopefully you all taking one of our cases in the near future. Take care, everyone.